At the conclusion of this lecture, you will know how to examine the different types of capital. You'll be able to illustrate the differences between various classes of shares, including treasury shares, and the procedure for altering class rights. You'll be able to understand allotment of shares and distinguish between rights issue and bonus issue of shares. You will examine the effect of issuing shares at either a discount or a premium. There are three main types of capital a company can have, and we will now examine each in turn. Debt. This refers to the company's capital that is raised by loans, whether through short-term or long-term loans. The loan usually brings with it interest that must be paid off by the company along with the regular installments. The loan will have a fixed date, which is the agreed date for which the loan must be paid off. This differs from equity capital and share capital because subscribers are not members of the company and therefore do not become part owners of the business and are merely creditors. Equity. This is capital raised by the company through selling its shares or by keeping some, if not all, of the profits earned by the company for the purpose of expanding the business. Share capital. This is capital raised by issuing shares in return for cash or other considerations. The amount of share capital a company has can change over time, because each time a business sells new shares to the public in exchange for cash, the amount of share capital will increase. Holders of share capital are referred to as shareholders. There are numerous types of shares a company can have, and we will now examine each in turn. Any company can create different classes of shares by setting out those classes and the rights attached to them in the company's articles. If a company has only one class of shares, they will be ordinary shares and will carry equal rights. Different classes of shares within a company can carry identical rights, but very often have different voting, dividend, and/or capital rights. This is done for different reasons. Sometimes it is to attract a particular investor, for example, by giving him or her preference shares. In other cases, shares are given to family members or employees so that dividends may be paid to them because it may be a more tax-efficient means of making payments to them. In such cases, the owners of the company may want to restrict the rights attached to such shares, for example, by making them non-voting and, perhaps, by making it possible to take the shares back if circumstances change. The following are descriptions of some typical classes of shares. There are no legal definitions of such classes, and shares with the same name will have different rights in different companies. Ordinary shares. Most companies have just ordinary shares. They carry one vote per share, are entitled to participate equally in dividends, and, if the company is wound up, share in the proceeds of the company's assets after all the debts have been paid. Some companies create different classes of ordinary shares, for example, A ordinary shares, B ordinary shares, etc. This is done to create some small difference between the different classes. There can also be ordinary shares in the same company that are of different nominal values, for example, £1 ordinary shares and 10p ordinary shares. If each share has one vote, regardless of its nominal value, the holder of the 10p shares will get 10 votes for every £1 paid for them, while the holder of the £1 shares only gets one vote per £1. Non-voting shares. Non-voting shares carry no rights to vote and usually no right to attend general meetings. What voting rights do shares have? Such shares are widely used to issue to employees so that some of their remuneration can be paid as dividends, which can be more tax efficient for the company and the employee. Redeemable shares. These are shares issued on terms that the company will or may buy them back at some future date. The date may be fixed, for example, that the shares will be redeemed 5 years after they are issued, or at the director's discretion. The redemption price is often the same as the issue price, but need not be. They may also be redeemable at any time at the company's option. This is often done with non-voting shares given to employees, so that if the employee leaves the company, his shares can be taken back at their nominal value. There are statutory restrictions on the redemption of shares. The main requirement, like a buyback, being that the company may only redeem the shares out of accumulated profits or the proceeds of a fresh issue of shares, unless it makes a permissible capital. Preference shares are often redeemable. Deferred ordinary shares. Shares on which no dividend is paid until other classes of shares have received a minimum dividend. Thereafter, they will usually be fully participating. Management shares. A class of shares carrying extra voting rights so as to retain control of the company in particular hands. This may be done by conferring multiple votes to each share, for example, 10 votes each, or by having a smaller nominal value for such shares so that there are more shares, and so more votes, per £1 invested. Such shares are often used to allow the original owners of a company to retain control after additional shares have been issued to outside investors. Preference shares represent a more secure form of investment than the ordinary share. The reason for this is that preference shares receive a fixed date of dividend before any payment is made to the ordinary shareholders, and usually they enjoy priority over ordinary shares with regard to repayment of capital. The actual rights enjoyed by the preference will be stated in the company's Articles of Association. Preference shareholders cannot insist on receiving a dividend payment, but as their dividend rights are usually cumulative, any failure to pay the dividend in 1 year has to be made good in subsequent years, subject to the company's profitability. Company law enforces the strict rule that dividends, whether on any ordinary or preference shares, cannot be paid out of the company's capital. Although, as with ordinary shares, the holders of preference shares are members of the company. Their voting rights are restricted to any period when their dividends are in arrears. Every company has an authorized amount of shares it can issue legally. Of this amount, the total number of shares owned by investors, including the company's officers and insiders, the owners of restricted shares, is known as the shares outstanding. The number available only to the public to buy and sell is known as the float. Treasury shares are shares that were once a part of the float and shares outstanding, but were subsequently repurchased by the company and decommissioned. These shares do not have voting rights and do not pay any distributions. A company can decide to hold on to treasury shares indefinitely, reissue them to the public, or even cancel them. Now turning to the issue of changing class rights. There is some statutory protection given to the holders of a class of shares against the rights on their shares being altered. A minority class of shares or a class of non-voting shares would otherwise be vulnerable to the rights on those shares being altered by the majority. For example, through the alteration of their rights by a special resolution in which they have had no right to vote on. This is a complex area, and for the purpose of the ACCA exam, it is useful to be familiar with the concept and the legal principles. Under the Companies Act 2006, Section 630 provides that class rights may be varied only in accordance with the Articles, or if either a. The holders of 3/4 in nominal value of the issued shares of that class consent in writing to the variation, or b. A special resolution, 75% majority, is passed at a separate general meeting of the holders of that class to sanction the variation. There is no statutory procedure for converting shares from one class to another. It may be done with the consent of all the shareholders affected. The safest course is to pass a resolution to which all the shareholders consent, because in practice, changing the rights on one person's shares may well have an effect at least in practice, on the rights of all the other shareholders. In order to register for incorporation, Section 9 of the Companies Act 2006 requires companies with share capital to submit a statement of capital and initial shareholdings, and Section 10 requires the nominal value of those shares to be stated. The designated amount set out at the initial registration of the company establishes the nominal value of the shares in the company. Once issued, the market value of the shares may diverge from that nominal value, but that nominal value remains fixed unless altered through a strictly regulated procedure. It is possible for a company to require prospective subscribers to pay more than that nominal value of the shares they subscribe for. This is especially the case when the market value of the existing shares are trading at above the nominal value. In such circumstances, the shares are said to be issued at a premium, the premium being the value received over and above the nominal value of the shares. Section 610 of the Companies Act 2006 provides that any such premium received must be placed in a share premium account. The premium obtained is regarded as equivalent to the capital, and, as such, there are limitations on how the fund can be used. Section 610 provides that the share premium account can be used for the following limited purposes: to write off the expenses, commission or discount incurred in any issue of the shares in question, to pay up bonus shares to be allotted as fully paid to members. Section 687 also allows for the share premium account to be used to finance the payment due for any premium due on the redemption of redeemable shares. Applying the rules relating to capital maintenance, it follows that what the share premium account cannot be used for is to pay dividends to the shareholders. It is a long-established rule that companies are not permitted to issue shares for a consideration that is less than the nominal value of the shares, together with any premium due. The strictness of this rule may be seen in Oregon Gold Mining Company of India versus Roper. In that case, the shares in the company, although nominally £1, were trading at 12.5 pence. In an honest attempt to refinance the company, new £1 preference shares were issued and credited with 75 pence already paid. Note the purchasers of the shares were actually paying twice the market value of the ordinary shares. When, however, the company subsequently went into insolvent liquidation, the holders of the new shares were required to pay a further 75 pence. This common law rule is now given statutory effect in Section 80 of the Companies Act 2006. If a company does enter into a contract to issue shares at a discount, it will not be able to enforce this against the proposed allottee. However, anyone who takes shares without paying the full value plus any premium due is liable to pay the amount of the discount as unpaid shared capital, together with interest at 5%. Also, any subsequent holder of such a share who was aware of the original underpayment will be liable to make good the shortfall. The reason for such protection in relation to preventing the issue of shares at a discount is the protection of the company's creditors. Shareholders were seen to enjoy the benefit of limited liability, but that privilege was only extended to them on the basis that they fully subscribed to a company's capital. And, in turn, that capital was seen as a creditor fund against which they could claim in the event of a dispute. In private companies, it is possible to avoid the strict effect of this rule by exchanging shares for property that is overvalued. See the case of R.E. Ragg, 1897, for more information on this aspect. In public companies, all such non-cash consideration has to be valued. It should also be noted that the above only applies to shares. Debentures may be issued at a discount. This is the case even when they are convertible into shares, as long as they do not carry an immediate right to conversion. See the case of Mosley v. Coffee Fontaine Mines, 1904, for more information on this aspect. Rights issue of shares. This is the issuing of shares to existing shareholders, which provides them with an opportunity to buy additional shares directly from the company in proportion to their existing holdings. This must be purchased within a fixed time period. In a rights offering, the subscription price at which each share may be purchased is generally at a discount to the current market price. Rights are often transferable, allowing the holder to sell them on the open market. Bonus issue of shares. These are shares of stock given to current shareholders in a company based upon the number of shares that the shareholder already owns. While the issue of bonus shares increases the total number of shares issued and owned, it does not change the value of the company. In conclusion, debt, equity, and share capital are the types of capital a company can have. Companies can create different classes of shares by setting out those classes and the rights attached to them. The issuing and changing of share rights are protected by common law and statutory principles.